Hello and welcome to the Health, Occupations, and Long-Term Care Subcommittee. We have on our agenda today 3 bills. 2 are each other's cross files, so we'll be discussing sort of 2 sections, 2 bills really, with a third being the cross file. The first one we're going to discuss is House Bill 821, the Career Pathways Bill, which we did discuss earlier in session. And its cross file, Senate Bill 518. So we'll discuss that first, and then the second bill we'll discuss is Senate Bill 523. Before we get started, I got this thing that I really wanted to share. This is probably our last Health Occupations Subcommittee meeting for the session, and hopefully many of us will be coming back. One person we know is not coming back is our beloved Delegate Krebs, who probably knows more about health occupations than I do, always reads the bill, works really, really, really hard in the subcommittee, and we're really grateful for her. So I got her one of these fancy citations, and it says, to Delegate Susan Krebs, in recognition of her exceptional and dedicated service on the Health Occupations and Long-Term Care Subcommittee. So we really just wanted to thank you and show you our gratitude for all of your hard work, because we really appreciate it. It's the sexy issues, you know?
Look what I just got from my husband.
Oh, well, he's better than me.
No, thank you. I appreciate it very much.
So let's go ahead and start first on House Bill 821, Career Pathways for Healthcare Workers Program, which is Delegate Turner's bill. Lisa, do you want to remind us about this bill?
Sure. House Bill 821 establishes the Career Pathways for Healthcare Workers Program administered by the Division of Workforce Development and Adult Learning in the Maryland Department of Labor. The purpose of the program is to provide matching grants to hospitals or related institutions that pay for training programs attended by healthcare workers, with the goal of providing increased opportunities for healthcare workers to receive training across the state. A training program is one provided for healthcare workers by a historically Black college or university or a community college. The amendments that were distributed require that identified training programs be consistent with labor market needs, specify that grant funds are for training that was attended by healthcare workers, require that wage increase information be given to interested healthcare workers, strikes a specific wage increase amount and specifies that a wage increase be consistent with market trends, and provides that grant funds pass through a specific fund based on certain bargaining agreements.
Okay, so the amendments are identical to the amendments that were adopted in the Senate, right? And these, I understand, are the amendments that, in large part, the Hospital Association wanted these amendments. They were very comfortable with the bill, with the amendments, and they couldn't be here at subcommittee today, so they wanted me to make sure the committee knows that they really like this bill. They think it's an important tool in the toolbox, and they would very much appreciate the amendments as well. We do have, I see Len Luke, I don't know who's calling me, but I'm hanging up on them. I see Len Lucci is here to talk to us, but first let's see if we can get the amendments on and we'll discuss the bill as amended. Can I get a motion on the amendments?
Move the amendments.
Second.
All right, any discussion or questions about the amendments from the committee? All in favor of the amendments say aye. Aye. Anyone who's opposed, raise your hand in the chat. The amendments pass unanimously. Okay, on the bill as amended, Len, do you have anything that you would like to add?
Just that this is a really important program to get current healthcare workers to be upgraded to higher certifications. And I'm joined here by Dr. Brad Phillips, the president of the Maryland Association of Community Colleges, who also could emphasize the importance that it be to everyone's local community college to have rising healthcare workers going through their institutions.
Excellent. And so the basic premise of the program is that working through the Department of Labor, we're going to be able to have matching grants for the employers who are supporting their current workforce in increasing their education training and also increasing then their compensation once they get that training, right?
That is correct. Thank you.
Sounds like a great idea to me. Any other questions from the committee? I don't see any hands up on that. Does anyone want to move the bill? Delegate Riley.
Yep. Delegate Riley, you're on mute.
I think we know that by now. Sorry. Thank you, Madam Chair. So does the bill still state that that the training has to be done at one particular university and community colleges, or can it be done anywhere? any of our institutions in Maryland.
Any HBCU or any community college.
So all of the community colleges, as well as the 4 HBCUs that are listed.
Great, thank you.
Delegate Krebs.
Thank you. I just want to mention, I most frequently do not support mandated spending. And one of the reasons, especially this year, is because when we passed the bill, I guess in 2020, that would give budget authority to the legislature to add to the budget when we need to. And I think that's a tool that we should have versus mandating it forever. However, on this particular program, I think it's very, very important. This is a true need, and there's a lot of stuff I vote against, but this one I think is worthy of it. But I still remind the body, as our esteemed appropriations chair said today, the amount of extra spending that has occurred this year through some of these bills is astronomical to me. And I think it's a challenge to what our real priorities are. This to me is a priority, but I just remember that the tools that you are going to have next year with being able to add money as you see appropriate each year versus just putting in legislation forever. But I do support this, and I'm glad the community colleges are the most nimble colleges that we have. They do it cost effectively. So I'm glad the community colleges are in there throughout the state.
Excellent. Thank you, Delegate Krebs. I actually noted that when Chair McIntosh said it on the floor as well, and I thought, what a terrible day to have this bill in subcommittee. But I'm glad we all recognize that this is just such a high priority that we need to acknowledge that. Any other questions or comments from the committee? Or can I get a motion on the bill as amended?
Move the bill as
Move as
amended.
amended. Second.
All right, moved and seconded. Any further discussion? All in favor of this bill, say aye. Aye.
Aye.
Anyone who's opposed, raise your hand in the chat. We'll make sure to note you. I am not seeing any hands, so the bill passes unanimously. Great job. We have the same now identical cross-file, which is Senate Bill 518. So unless anyone wants to discuss it further, we can just call a vote on 518, which is identical to the House bill we just amended.
Move the bill.
Perfect. Moved and seconded. All in favor, say aye. Aye.
Aye.
Anyone opposed? Passes unanimously. One good thing for our healthcare workforce. Thank you, committee. Now we have Senate Bill 523. It's 147. So I just want to make sure the committee knows we decided to just have the meeting for 1 hour. So that gives us, if we wanted to take it, who's good at math, about 45 minutes to discuss this bill. I don't know if we're going to need all of that time, but I do want the committee to feel, like we've asked and answered as many questions as possible since we got this bill late. So it is Senate Bill 523, Health Occupations, Licenses, Certification, and Registration Immigrants. And Lisa has the bill, so we just heard it, but you can remind us again what the bill does.
So as amended in the Senate, the bill prohibits a health occupations board from denying a license, certification, or registration to an immigrant if the individual meets the relevant educational, training, or professional requirements. The bill also requires health occupations boards to require each applicant for a license to disclose his or her social security number or individual taxpayer identification number and record the number on the application.
Had the hearing on this. I see Michelle from Delegate Pena-Melnick's office has joined us. I believe there are some other stakeholders. Robin Elliott from the nurses is here to discuss this. This is another bill that the Hospital Association wanted me to make sure to convey to you all that they are in support of. They couldn't be at the subcommittee today, but they think that this is another important tool in their toolbox. So they wanted the committee to know that they are in support of this. I guess we'll go ahead straight to questions from the committee and we can continue the discussion we started in the committee hearing a few minutes ago. Go ahead, Delegate Krebs.
Thank you. And we've had very little time to read this stuff between the hearing and now, like 15 minutes. And this is pretty important. So I'm reading in the fiscal note. It says federal law expressly denies eligibility to non-exempt aliens for professional license or commercial license provided by an agency of a state or local government or by the appropriated funds of state or local government. And then also in some testimony that we had submitted, it said federal law is plainly designed to preclude those here illegally from receiving commercial and professional licenses as a public benefit under Title 8 USC 1621. So given that, I think the difference that you guys gave some information during the hearing about people that went to school here and that have come here, where they're married to someone here, but they don't have their citizenship yet. So the differential that I have a problem with here is that lawfully here versus illegally here. So how can we reconcile that with federal law? The illegal versus lawfully present with a green card or whatever.
So it's interesting that you asked that, and I'm going to let you know that I saw this bill come over from the Senate and spent all day yesterday trying to dig a little deeper. So I have a little bit of a benefit over the committee members who just are going through the testimony. So that's one of the reasons I want to make sure you guys have time to have your questions, answers, and think it through. And I will make sure you know, this was not a unanimous vote over in the Senate. So I understand it can be a politically complicated issue. The concept with this bill, and Michelle, correct me if I'm wrong, is that the health occupations boards are not the right place for determining or assessing citizenship. And to be clear, I spoke with all of the health occupations boards yesterday, and they do not do that. It's not something that they do. There's no checkbox on the form saying, are you a US citizen? It's not their intention. It's not their mission in life. It's not their purpose or their goal. This bill came about in part because one health occupations board, which is the Board of Nursing, but none of the others, was as part of their process, which in part was designed around the initial interstate compact, was requiring Social Security numbers, whereas others were already allowing Social Security numbers or an ITIN. And for the background checks, which we do, which all of our boards do, that line for Social Security number can be left blank and the background check is still done. That's a federal process that's done. So I think philosophically, and I don't know that everyone will agree with thinking about it this way, but for me, the way that I was able to understand this bill is that sort of to the point that Delegate Saab was making earlier, it's not the health occupations board's job to determine if someone is here with work authorization, right? Their job is to determine if someone is competent, capable, and should be licensed. But we have not ever as a state expressly required the health occupations boards to determine if someone has work authorization and is legal to work. It's not something they've ever considered part of their jobs or consider currently as part of their job. Nor is it in Texas or Florida or Georgia or any of these other states where people are currently getting health occupations licenses and then traveling to Maryland to work with them. So I think that that's a really important concept, right? So the points that Delegate Saab was making is there are some requirements incumbent upon employers, right? If you're filling out an I-9, you have an obligation to make sure someone has the documentation to work. That's incumbent on the employer. It's not the responsibility of the licensing board. The challenge that we have seen, and particularly with the Board of Nursing, I see Robin Elliott here, so she may be able to speak to this too, but is that because of all the backlogs and the delays, we really can't afford for these people who might otherwise be falling through their cracks to have delays in their licensing. So, for example, in the situation of a spouse who is here, say the husband is here on a H-1B visa, they're a highly sought out cardiologist and some hospital needed them here. And then their wife comes with them and they're a nurse, perfectly capable of working in the United States. They have great nursing training, but they don't necessarily have that work authorization because they're not the one with the H-1B visa. They could, under this bill, apply for licensure using an ITIN, which you can get in 6 weeks, while they're waiting 7 months or so for their work authorization to come through. And at the point that they get a job with a hospital, they can also expedite that process. I think that the best use of this bill is for those circumstances where we have people who are highly trained or trained at all, right? Trained, qualified, capable of providing the care, educated, maybe in the US, maybe not in the US. But the point is we know that they're skilled. We want to make sure that the licensing boards have the ability to do their due diligence and determine whether they should be eligible for a license, which is a separate process from determining whether someone is eligible to work legally. We're hearing from the Hospital Association and the long-term care facilities that they think this is an important tool. And they certainly are, it's incumbent upon them to follow the law about only hiring folks who are eligible to work. So
Okay,
that's
and
the
you-
best
and-
answer I could come up with.
No, I got your answer, but the two things you didn't, there's a difference. You say the boards right now, it's not their job, and I get that. But everyone that has a social security number is here legally. That's why and so the boards have to collect that social security number. So they don't have to worry about that. Now we're basically saying you can have an I-10. Any one of us can call in 5 minutes, go online and get an I-10. Takes, boom,
Well,
boom.
it takes 6 weeks. It takes 6 weeks, but yes.
Well, usually you can get them like boom right away. I mean, I could get online today and have an I-10 number, and I've done it before for many different businesses. So I don't think it takes 6 weeks. So anyway, so the question becomes then, there is no verification that a person is. I don't care if they are a citizen or not. I care that they're here legally, and so that's my rub. But for the interstate compact in the Board of Nursing, you didn't answer that question. The board is required through the interstate compact, and I don't know what other boards are, to collect and verify social security numbers as part of the licensure process. So how does that affect not only this compact, but all the board compacts that we are involved with?
So I did talk to the Board of Nursing about that question exactly this morning. And they said that the compact continues to require that. And so licenses issued for nurses under this would be a single state license only and not a compact license. And that's the process that they would follow. So they wouldn't get a compact license because they would not be presenting a social security number.
All right, so and I have one other question. In the judiciary, Maryland Judicial Conference is opposed to the bill as drafted, and they talk about, and I don't disagree with this. It says there's nothing in the bill that says professional requirements for licensure includes character and fitness review and not just meeting education, training, and other administrative requirements. Is that in the bill, the character and fitness review?
So the judiciary was exempted. All of their concerns were addressed when we removed this and just became health occupations boards. So they were concerned particularly about the legal profession.
No, well, I'm asking sort of the question too. I don't care what profession it is. Most of them have something in there. It includes character and fitness review. Is that in the bill for these health occupation boards?
I'm seeing Robin Elliott nod. So why don't you go ahead and say what you can say?
Great. And Delegate Krebs, to the earlier honoring of your sort of knowledge and expertise in health occupations, you are absolutely right. I think in every single health occupations law, there is language around good moral character. So that's already in the existing law. I think whether it's for nurses or occupational therapists or speech pathologists, and this bill wouldn't change any of that.
All right, and just one last comment, and this is just my opinion. I do not believe that anyone can meet the character and fitness, that line when they are not following the laws of the United States of America and being here legally. And there's ways to come here legally without being a citizen. And that's my rub with all of these things is, it's a law. It's a law of our land, and we need to honor that. So, to skirt around that, I know we have a shortage. But these people, there's ways to get here legally. They can get green cards, they can get other things. And there's no time limit in here to say they must do it in a certain amount of time. So they can come here, get the license forever, and there's no incentive to get here legally. And that's, to me, a character issue that would preclude me from being able to support this, because it's not even in here that they must have applied, they must have tried, they must be waiting to be here legally. Again, not citizenship. That takes a long time, I get that. And that's a fundamental problem that I have with this type of bill. If you wanted to put something in here to say legally, if they're legally present in the country, fine. But right now it leaves it that they can be illegally here and there's no time limit. So that's what I've got to say. Thank you.
Thank you. Delegate Morgan.
Thank you, Madam Chair. Session's almost over.
So close, so close.
My question is, this is licensing for nurses, correct?
It's all health occupations licensing.
All health patient, doctors, nurses. Can you so for doctors and nurses, so they would have prescription authority and other things like that, correct? And they will perform all those tasks.
Once they're licensed, which obviously they would have to go through all of the same exact requirements for licensing that anyone else does.
So
and meet all the same standards.
can you tell me, how could a doctor or a nurse or a healthcare professional lose their license? If they committed a civil crime?
Do you want to, I think each occupations board has different standards, so it depends. Maybe I'm looking at Robin. Do we know about
Yeah.
the nursing board standards?
So there's actually a section of law, and I'm forgetting the exact number with section, but says that all the different health occupation boards, that they have to take each
Yeah, go ahead, I'm up.
So
each case on each situation on a case-by-case basis, but they certainly could deny a license based on someone's prior actions, a conviction, or some kind of liability if they believe that will affect public safety. And that's the same, I think, across all the health occupations.
So I guess my concern is, we started this hearing off talking about this bill, talking about licensure and what it is. And the main goal of the licensure is to assure that the public and the person working on you has some degree of level of competence. Isn't that so?
Absolutely.
So how do you think the public would react if the person that would possibly prescribing to you and working on you and providing you some type of service was here illegally, which is like a criminal civil offense, may I add? What do you think the public's take on that would be, Miss Elliott?
So the nurses are supporting this bill because we do not believe competency is related to immigration status.
Well, you're saying that nurses, and I don't know if you're speaking on behalf of the board, but I can speak on the letters of opposition to this bill, which is from several nurses that don't agree with this bill because they feel that it's expanding licensure undercuts their profession, and they're concerned about public risk. You want to take a shot at addressing that?
Sure. And just to clarify, I'm speaking on behalf of the Maryland Nurses Association.
Okay.
And they're a membership organization with the legislative committee, just like your committee, and took a vote on this bill. And they looked at, really what drives determination of competency. And it's both education and then making sure in terms of nursing, taking the national exam, which is called the NCLEX. There are ways for people from outside the country, if that happens to be the case, if they've taken a different national exam, the board looks at that. But that competency is based on those things and not on immigration status. And so
Okay.
that was the position of the Maryland Nurses Association.
So let me ask you a couple other questions. So the Social Security number that I've personally had, and I think the majority of the people in this room have had since they were born. You get a Social Security number when you're born. If that's the main identifier that we use to, tie people to their licensure, and now we're going to transition that to an ITIN number. That number expires every 3 years. So
I think
how do you anticipate?
the ITIN language in this bill is just limited for folks who don't have a Social Security number. The vast majority of health occupations licenses would still be, and again, they're not
Absolutely,
really
but that's what the
tied to
bill
the
is.
number. It's just used for the background check.
And Delegate Morgan, I don't have every health occupations license cycle memorized, but nurses have to renew every 2 years. And so you have to update your address and any other relevant information. So in that time, if you've obtained a Social Security number, you would have to certainly update the board.
So do you believe, okay, with that, but I don't think the legislation says that once you change your ITIN number, that you have to update your licensure with the board.
I think the law.
Yeah, I agree with you. That's a great amendment. I think we'll probably propose it here in a minute.
Well, I think the law requires you to meet all the requirements that the board imposes. And if they need to collect that information for criminal history records check or for any other reason, you have to provide that as the board. You have a general statutory, you've given the board's general statutory authority to require whatever information they need to process the license.
So the general board has the authorization authority to require numbers and licenses, but just not to enforce immigration status. Correct? Am I hearing
They've
that
never
correctly?
had the authority to enforce immigration status.
Gotcha. I appreciate the questions. That's all I have at this time. Thank you for answers. Thank you.
Delegate Riley.
At this time, thank you, Madam Chair. Before I start talking, unmute. I guess my biggest issue, kind of, from the colleagues before me, some of their concerns, but it really, it bothers me the fact that this really encourages more bad behavior on folks. So, we are adults, we're teachers, we're legislators, we're everything in society that we're supposed to be teaching law-abiding rules. And then here we're encouraging, for these folks, they're already here illegally. So now we're encouraging them and giving them opportunities to get licensed. I mean, I think that's just, like a slap in the face of the folks that are here legally and go through the process. Now, I do understand, the immigration process, it really does need to be fixed. It takes a long time, for you to actually become a citizen. But there are other ways, like you said, for them to get documented, and at least, shouldn't we be encouraging them to do the right thing? Like, if you're in the process of wanting to become a U.S. citizen, then you have the opportunity to go get a license. There just has to be some kind of, movement forward to trying to become here legally. And we seem to never want to do that. We don't address the real problem and the root of the problem. So, I would like to, something in this bill to say, okay, well, we'll do this if you're, so long in the process of becoming a U.S. citizen. Like you said, some of these folks have been here for years. I mean, they should be 4 years ahead of becoming a U.S. citizen. Why aren't they doing that? Because we're not encouraging them to do that. So I think that should be part of this. So that's,
So, we have a lot of other members who want to talk. And I wish this conversation were happening earlier in session so everybody got to really understand this bill and hear from more of the people who would benefit from this bill. It is my understanding, based on spending a lot of time with this bill, that, this pretty clear language that just says the health occupations boards are not going to deny a license based on citizenship status. It allows the licensing process to move forward, which is important. We have talked endlessly about removing barriers within the licensing process, that there are so many backlogs and you can get lost in the system, and delays can go on for months and months and months, and the workforce isn't there for the employers to hire when they need it. We have had employers in this subcommittee advocating tirelessly for us to do everything that we can possibly do to try and help them eliminate as many of these barriers as possible, because they're desperate for workers. What this bill does not do in any way is change the federal law around who is eligible for employment. So I just think it's really important to keep that in mind, right? We're trying to remove licensing barriers so that people can become licensed. We are not making it possible for a hospital or a long-term care facility or anyone else to legally hire someone unless they're exactly engaging in that process that you were talking about, Delegate Riley. And there's 25,000 that I could come up with yesterday, different scenarios and situations for different visa statuses and different authorizations to work under different categories. And all of those have backlogs at the federal level for months and months and months. So we can't really, I don't think we can envision all of the approved scenarios and write legislation that allows just for that. I think that this broad legislation that just says, let's have the health occupations boards look at whether people are qualified and have the appropriate education and training to do the job. That's what the license is for. And then that removes those barriers that are currently created for getting folks licensed. It doesn't establish any authority for anyone to hire someone. So if your concern is someone who is hiring someone who is not here legally, your concern is with the employers,
The employer,
right?
right.
It's not with the
Mhm.
health occupations boards. So that's that, I hear your concern that we wouldn't want to reward people who are here not legally. But that is not really have to do with authorization to license so much as practices on the employment side. So that's all I can think of to say. I see Delegate Cullison followed by Delegate Saab, followed by Delegate Bagnall. So let's hear from Delegate Cullison.
Thank you, Madam Chair. Yeah, I'm off mute. So I'm afraid I'm going to keep hitting the horse that you just hit. Sorry about that. But I think, I think the first thing that the public cares about in terms of their healthcare providers is competency. And that's what the board does. The board decides whether or not the person is competent. So there's potentially a pool of folks out there in our state who are here, maybe in the process, maybe just starting the process, or maybe just arriving, who have the competency to help us with our crisis, with our healthcare staffing crisis. I mean, so there's a possibility for us. But even if they get that license by proving their competency to the board, that doesn't give them a job. That gives them the ability and the opportunity to apply for a job. And then, as the good chair said, it is up to the employer to do the work to determine whether or not this person has the approval status wherever they are in the process that that will enable them to be hired. So I just, again, it's the same horse. It's just the license that will then open up a pool, I believe, of potential providers to help us now in a real healthcare staffing crisis. So thank you, Madam Chair.
Absolutely. Delegate Saab.
Thank you, Madam Chairman.
Hear a lot of you.
I mean, obviously, there's a lot of issues with this bill, and not just philosophical. I mean, yes, some of us believe that, you have to be here legally to get a job. And for someone that's been through the process, the vetting process is a very difficult process, but it also vets people that are coming to the United States that they don't have a criminal background in their own countries. When you license people, even though you do a background check on them, you're circumventing that part that you are here. We don't know who you are. That's number one. Number two is that there were discussions earlier when we talked about that the hospitals have to sponsor the employee, which is very difficult to begin with. And the reason for that is because the employee can only sponsor some nurses for employment based on a green card or U.S. Immigration Service, because the Immigration Service have set limits of which type of nurses qualify for those visas, which is an H-1B visa. Specifically, that the United States ICE or Immigration Service has stated that registered nurses generally do not qualify because the position does not normally require a U.S. bachelor or higher degree in nursing. So this is one of the problems that's not going to give path to anyone. The other problem that this bill has.
Well, let me just interrupt you because
if you end up applying.
Let me just, I want to hear your other problem.
I-765 form.
Delegate Saab, are you ignoring me? Because I'm the chair.
Working without a green card. Huh?
She's talking.
Delegate Saab, I just wanted to, I hear you on the H-1B issue. I just want you to know that when I spoke with the long-term care facilities, they said that they have a lot of workforce come in on the I-140 and that this would be very helpful for them. So just wanted to note that. Go ahead, back to what you're saying.
Right, but to become legal, to work here legally, you have to have the I-765 form. And if you are caught working illegally under that, you jeopardize your green card status, and you also will be banned from entering the country 3 to 10 years. So as our good chairman would say, this bill is not ready for prime time. It needs a lot of work. It's coming very late into session. I appreciate the intent. I just think it just needs a lot of work, and it's not just philosophical differences. I think there's a lot more. And the most important thing is the safety of our patients. And even though, it sounds good on the outside, maybe, But this bill is, obviously it's getting rushed here, and we need to spend a lot more time because there's a lot of different information. So we want to make sure, as our committee always does, bring out great product. And if we vote this bill in its current form, it's not going to be a great product. Thank you.
Thank you, Delegate Saab. I will let you know, because I was looking up the I-765 as well and figuring out how that process would work under this process. That can take about 7 months, 7 to 12 months to process right now. Obviously, if I were an employer, and one of the many employers who have written to us and asked us to support this legislation as one of the many tools in their toolbox, if someone had a license and then I were working with them to get the 765, they would presumably start that 765 application at the same time they're starting their nursing application, which they can then do under this bill because we can use their ITIN. So we don't have to wait the 7 months for that 765 process to come through from the feds. We can start with processing their nursing application with their ITIN. So it prevents delays, right? It streamlines the process. It doesn't circumvent any law. It doesn't encourage people to take jobs without their 765, but it allows us to tighten the timeline and get more qualified, legally working nurses in the hospitals and the long-term care facilities right away. So I think that that is the intent of the legislation. I think that the language that is in the bill is very clear. I think that it is largely codifying current practice and clarifying for one of the boards, the Board of Nursing, that this is the current practice and that it's working. Delegate Bagnall.
Madam Chair, real quick, just to respond on the last thing. So the cost, by the way, for the 765 is expensive, and not every employer is just going to go through it because it's not just a matter of applying. You have to get, a lawyer, and not every hospital system or every employer is going to sponsor someone that just because they have a nursing license. So it's usually done for higher degrees, but it does cost a lot of money. It's not as simple as many of us think here. Thank you.
Delegate Bagnall.
Thank you, Madam Chair. And thank you for this bill. I actually think it's quite important because we don't have enough staff for prime time right now, which is why we need to look at moving this. But I just wanted to make sure I fully understand the bill. You already answered one of my questions, was in that this does not supersede federal law in any way. But just to confirm, licensure doesn't alter immigration status, and just because the boards have the ability to provide a licensure without this restriction that we're clarifying, that this is not a disqualifying if they don't have a social security number, it does not require the board to issue a license either. Is that correct under this bill?
Absolutely. If there's another reason to deny a license, they would continue to deny the license, of course.
So that's the public safety guardrails is the board.
Yes, absolutely.
The licensure process. Okay, thank you very much.
Delegate Morgan.
Thank you, Madam Chair. So we had some talk on the 765 and an H-1B visa. I know a requirement for the H-1B visa is anyone that's working in that capacity, it must be displayed at the front door of their business along with their salary that they're paid. Do you envision any type of amendment that might be useful to disclose people that are here illegally and working with a Maryland license as a possible disclosure of their status?
I think that is a misinterpretation of the bill as I read it.
Well, so what I'm concerned about is, so we have Maryland licensure and we're saying that to the public, like, okay, these people are competent and they've met the basic needs to be a health professional in the state of Maryland and they have a license. Here's the problem. Once you have a Maryland license, and if you're hired illegally, I feel like that can probably be taken advantage of that person. If they're on some type of H-1B visa, if they're trying to transition to a citizen, that's a long time. And if they're being sponsored by a company, that's also a long time, up to 5 or 7 years. Now, where an American employee would job jump and be on their way to a different hospital or something and maybe pay them, whoever would pay them more. If someone was here illegally working under this licensure, it's almost like an indentured servant program where they wouldn't job jump because they're beholden to their sponsor. You see what I'm saying?
I do, but I don't, because what you're saying is under the circumstances, someone would be here working illegally with a sponsor. So if they have a
If you're under
sponsor,
a
how are
sponsor
they?
program, and this is what you're telling me you're intending to, you have to admit that if you could hire an employee that was guaranteed not to leave your place of employment for next 7 years, you might be able to get them at a discount versus somebody that's could job jump. And what I'm saying is that maybe this licensure and their status should be disclosed so other employees know that. That's the theory behind the H-1B visa and having disclosed their salaries and status.
Interesting theory. I appreciate the information there. See a hand up from Delegate Krebs. Did you have something to add to this conversation?
Yeah, I was just going back. I went back to my first question. I guess I didn't really get an answer about the federal law plainly is designed to preclude those here illegally from receiving commercial and professional licenses under Title 8 USC 1621. I'd like someone, I mean, maybe we've had an hour between having the first hearing on this and what we're doing now, and this is a really big deal. So I'd like someone maybe on staff to look that up before we vote. And the second thing, it bothers
Wait,
me.
hold on. Let me make sure Lisa got that. You want someone to look up what specifically?
It's
before we
federal
vote?
law, Title 8, USC, Section 1621. Basically,
The part
it's precluded-
cited in the fiscal note.
It says federal law is plainly designed to preclude those here illegally from receiving commercial and professional licenses under Title 8. So I'd like to know what Title 8 says. Second thing, when Delegate Saab mentioned about being vetted, as we talk about background checks and having all these things that we do. When you're here legally, you've been here. When you come here legally, you've been vetted. That's how you get your status. So there is some vetting to get you here. That's why it takes a long time. If you've lived here forever, you're vetted because you have your background here. And if you have a criminal background, it's in the United States. If someone comes here for a couple of years, there's no way to vet them of where they came from because they haven't been vetted through the immigration system. And that's a problem. I mean, I think it's a huge problem with regard to health occupations because they.
But I think Delegate Krebs, I'm confused because again, I will come back to none of the standards that any of our health occupations boards for determining qualifications change under this bill. So if you want a license to be a nurse, you have to have gone to an appropriately accredited school. You have to have the training and all of that the same yesterday as tomorrow. None of that is changing. So that I would think is fulfilling that, the same exact rules for whether you're qualified
the background
apply. So I'm not sure what you're getting at.
The background check piece that I'm talking about. If you've been here if you've lived your life here, or you have your background is all here. So any kind of criminal activity, any kind of problems on your record are going to show up during the background check process. When you come here and you haven't legally been vetted yet, that all hasn't happened from where you came from. It just starts from when you arrived here. And I know all of us have different situations you think of. I can think of situations where this probably would be harmless, but I can also think of situations where it may not be harmless. And you don't have that history because you haven't ever been vetted. You've only been vetted. Let's say you came here to college. You got those a couple of years, but you might be a 40-year-old coming here. So you don't have.
You might be one of these Ukrainian refugees coming on the temporary protected status. We got 75,000 Ukrainians here, many of whom have healthcare licensure.
I don't disagree with you, but you also could have an ISIS person. It could be either. You're looking at the positive of who could come. I'm looking at the concerns that could come, and it's an unequal vetting. So that concerns me. So I'd like somebody to tell us what federal law says. And it says here in the last words of the bill, the board may not deny a license or certificate of registration to an immigrant if the individual otherwise meets all educational training or professional requirements for licensure. But again, the background checks are not all equal. It depends on when the person came, where they came from, and there are a million different situations, and some are good and some are not good. My biggest issue is not having them here lawfully. Again, it's not the citizenship, it's the lawful presence. If this said they must be lawfully present, that means there's some vetting, and I could live with that. but this does not say that. And that's where I have an issue. And I don't think we've done our homework on some of the issues that were just brought up by Delegate Morgan and Delegate Saab. This is a very complicated issue. And I know that hospitals all need, believe me, I get all that. They're looking for us to figure out how to make it work. They don't do all the homework on it.
I hear you, and I have so much respect for you. I just really want to reiterate, it is not complicated because in most cases, we're codifying the existing practice. The federal background check already allows for this. Boards have been doing this. So that's why it's, I think it's almost more political.
If we're already doing it,
because particularly the Board of Nursing was enforcing differently from the other boards. And so we wanted clarification in the statute to the point of the federal law that you referenced, right? This federal law passed, I think it was in 1996. It said states need to proactively grant this authority. We hadn't yet done it. Although New Jersey and New Mexico and Illinois and Nevada and California have done that, we have not yet done that. Again, states like Texas and Georgia and Florida don't ask for social security numbers at all. And that's why we get our nurses, our international nurses with licenses through those states. So it's really not, I know it's probably scarier because it's coming late in session. And for that, I apologize.
We haven't had time to vet it. And you just named all of those states. And I don't know if they're all equal. Do they require lawful presence? Because there's a difference between having a social security number and not having a social security number, having lawful presence. And you're throwing out all these states. And I don't know that you could sit there and defend and say it's exactly the same as we're doing here. And that's
so
why
I can refer you to NCSL because we're going to have a couple hours before the voting session. So there are other states that have the language like you're talking about that is less open than this. But Nevada, Illinois, New Mexico, New Jersey, California prohibit lawful presence as a qualification for obtaining professional or occupational licenses. Specifically in New Jersey, allows licensure regardless of immigration status with no mention of lawful presence in New Mexico. All of these states that have large immigrant populations and a need in their healthcare workforce have been addressing this. And Maryland, unfortunately, is one of those. We have 3,900 nursing vacancies right now in the state of Maryland. And I will say, and I have not wanted to mention this because it will bring me to tears, but I have a constituent who was my age who passed away last week. And her 16-year-old daughter was at home caring for her in her dying days because there was no hospice worker and no home health care aide from the agencies to go there because the healthcare workforce crisis is so severe right now. And I don't want to be in a situation where someone's 16-year-old daughter is providing their basic maintenance healthcare needs in the end of their life because our healthcare workforce crisis is so great. And there's one tool in the toolbox that all of these other states, including red states, have done. That's why I think there's urgency here. So I respect that we can disagree, but that's where I'm coming from. Delegate Cullison. You're on mute, Delegate Cullison.
Thank you, Madam Chair. Thank you for your passion. I guess I want to know a little bit more about the federal law, and I'm wondering if maybe Robin Elliott knows something that she can share about that federal law.
If the federal law is lengthy, but the section I think pertinent to this discussion is that states need to collect social security numbers for the purpose of child support enforcement. But the federal law actually allows, if states designate it, to use some other identification number other than the social security number. I think Maryland codified the social security number requirement after the federal law passed, and never went back and looked at whether or not a board could also use something other than a social security number to have the screening done on child support. And I can say that again if it's helpful. Sorry, it was a little meandering.
I think let me do a synopsis. So the section of code that is the federal law requires either a social security number or any other identifying number. When Maryland codified it, we used social security number without sort of thinking forward here to the day we're in today. So it's perfectly allowable under federal law to use another number for these child support, for tracking child support, and that's what the statutory change is going to allow for.
Can I just
Yeah.
ask somebody to get this information versus somebody telling me, I don't know how to pull it up. Maybe somebody on staff could pull up this section I've mentioned several times, because it says federal law is plainly in our testimony. If someone could pull it up, we could read it ourselves and interpret it. And I think that's the best way to do these things. And having an hour to vet these things and get the burden should not be on us to make the case. The burden needs to be on the bill sponsor to give us the information, and then giving us an hour and saying, go investigate it, to me is not the best work that we can do with 3 days of session left. So if someone else
I
can do
think I'm
something.
just, Delegate Krebs, and I appreciate the timeline issue. I think that you're right. It's very unfortunate that we're under the wire with this. I wish this were not the case. That being said, and maybe I'm missing something, my understanding of the federal law is that the federal law passed and said you can't grant these privileges to people who are undocumented unless the state affirmatively says so. And this would be an action of the state affirmatively saying so. So, and again, we would be following many other states also affirmatively saying so. I believe it's pretty clear in the fiscal law explaining that that's what the federal law allows for. So I don't find it especially confusing, but I don't know if Lisa, you have anything to add to that? Is my analysis pretty accurate?
I'm just asking for somebody to get this document, federal code, and give it to us so we can read it.
Okay,
I don't know
we
anybody's
will get that to
interpretation.
you
It's a-
before we vote on it.
It's a
this
simple
afternoon.
request. Thank you.
Delegate Saab.
Thank you,
Delegate
Madam
Saab.
Chairman. Can anyone answer a question for me? Is what are the penalties for hiring undocumented immigrants?
We don't have, sorry, I'm hearing my own echo. I looked these up the other day too. I think there's all sorts of different penalties depending on the infraction. We don't have any of the employers who are asking for this legislation here with us on the subcommittee. I did speak with a number of the employers, and they were, again, yesterday I spoke with the Hospital Association, I spoke with the long-term care employers, and they were clear with me that their goal in this bill is not to hire people who are undocumented. It is to help people in the process to ensure that they are legal to hire. These large employers in the state of Maryland are responsible for following the law, and that's their intention.
Right, so in that case, you'll be open for an amendment to specifically put it in writing, since that's their intention. But I actually will tell you what the penalties are for hiring an undocumented immigrant, because you can be subjected to minimum of $375 per unauthorized worker for the first offense, maximum of $1,600 per worker, and any subsequent offense. And if you're found that you have engaged in a pattern of practice, which the hospitals technically could be, if we don't add this amendment, of hiring undocumented workers, they'll be fined of $3,000 per employee and imprisonment for 6 months. So, I mean, I agree with you that the reason for the bill is we're not disagreeing on the reason why we need the bill. I think what we need to at least clarify that if this is the intent of the bill, that it should be added that they have to prove legal status, whether documented or undocumented. So I would like to maybe ask council to maybe put an amendment for this bill to add this language that Delegate Kelly suggested.
Delegate Kelly did not suggest this language, but thank you. That
So
would be
what-
Delegate Saab's name.
So what would you like an amendment?
So it would just have to make sure they verify the status of the person that they're giving the license to.
So how can we,
Their immigration status?
Immigration status. I mean, they can provide their I-675, 765, or I-40. They can provide that or their status. Like they just need to prove that they're here legally, not they didn't.
So it sounds like what you're talking about, though, is a bill that would go in labor and employment, like that section of
Yeah,
code. This, again, it's the same issue with this bill. This bill deals with health occupations licensing. So if you're putting an imposition onto an employer, That would be an ECM bill, right? That goes into labor and employment. We can put all sorts of different regulations. Talk to Talmadge, who chairs business regulations. You can put in that bill, but it's not really an appropriate amendment on this bill because this is in the health occupations statute.
Well, it is because you're talking about the licensing boards. So the licensing board, before they issue the license, they just have to verify that this person here legally. That's all it's saying. It has nothing to do with going to a new bill.
So that's a different amendment than what you described. That's more like what Delegate Krebs was suggesting, I think.
Right. And I think that would make this bill, closer to some of the people that have. And I think you're right. If the intent of the bill is that, so why don't we just put it in an amendment? I agree with you. If this is our intent, let's just put it in writing.
I think that the challenge is that there are multiple, and this is what we heard from the sponsor of the bill, and I'm not sure if Michelle wants to add to this, but that there are folks who are in that gray area who we are trying to get to support them, we've supported them through their education, we've supported them up until this point in the process, and we're trying to get them to be functioning with a legal status and employable in the state of Maryland. So the point at which you issue the license isn't necessarily the final step in that process. The license, again, is not the same thing as having a job.
Yeah, but you can't get a job without a license. So you're giving them a license, but
It's
you
a
can't get a
chicken
job.
and egg circular problem that some of these people fall into. You can't get the job without the license. You can't get the license without the job. So you need to have the license ability to happen so that then you can go through the process of getting the work authorization because you have a job offer. That's the point.
Correct. And the state currently allows undocumented students to pay in-state tuition rates. They're allowed to go to community college for free. So again, like Delegate Kelly says, this is just another step in the process. We already are giving a couple of steps, but then they can't really do anything with that in our state.
Well, I still like to work on some sort of amendment to clarify the intent. And like I said, I agree with you. And if we can put some language in there that clarifies what the real intent, I think that will end up being a better bill.
Delegate Morgan.
Thank you, Madam Chair. I think to piggyback on what my internet seems to be going in and out. Can you hear me now?
Yeah.
Okay, sorry about that. It's like jumping around. Hey, the piggyback on what Delegate Saab's saying, what could possibly work out as an amendment, I think that might be attractive for all parties and protect businesses and don't want to put them in a situation where they're possibly hiring somebody that doesn't have a work requirement here, is why couldn't the license be marked differently if it was filed with an ITIN number?
Like a like a Jewish star or something.
Well, I was thinking about a range of numbers. Because it's, you're trying to protect businesses from hiring.
But as an employer, right, you have to fill out your I-9 form and you have to check your documentation. That doesn't change under this law. Right? That's your job as an employer. It's not the health occupation board's
look,
job.
I know we can say this and play over semantics by this, but it's a little disingenuous to lay this all on the employer, saying, hey, you know what, the employer has to check all this stuff. When the state could easily check this. The state is creating the licensure.
Morgan, you make it seem as though our licensing boards have no challenges. We've spent 87 days talking about the challenges faced by our licensing boards. You believe more than anyone that the bureaucracy and the paper pushers are struggling to get the job done. You know it's true. We can't pile more on these suffering, low-staffed government agencies.
So I think a lot of this is true, and it's caused by the COVID policy from like 2 years ago. And so now we're once again trying to make a correction that we caused, or was it just the circumstances of life events? And we've had numerous bills bypassing, giving temporary licenses. And now we're once again trying to license people here illegally. When, you look around, like the African-American community in Baltimore City has a 14% unemployment rate. Like if we wanted to license healthcare workers, I mean, there's a whole bunch of people not working. So
And we did just, I mean, literally when 20 minutes ago, we passed Career Pathways, which is $1 million investment in particularly HBCUs and other community colleges
So why don't we,
workforce programs.
so just to argue against the bill, because I'm on the bill now and I won't waste anyone's time, then why don't we let those policies play out? We have no magic wand. We're here 3 days before the end of session with another policy, making a major change. And I just don't think it's a good idea. So with that, I mean, if you want to move the bill, we can move the bill.
Let's hear from Delegate Collison.
Thank you, Madam Chair. I think Delegate Morgan just moved the bill.
I'm not sure he moved it. I think he
No,
wants someone else to move it.
No. Before I do that though, in terms of where the burden lies relative to employment, by federal law, the burden lies on the employer. So we're not changing that. I mean, it is, and our boards don't have the authority to do that and to be immigration police. So with that, Madam Chair, I'd like to move this bill.
Thank you. Do we have a second? I can second it. I see Delegate Bagnall and Delegate Lewis are away from their chairs. Would they like to come and vote on this bill? Delegate Lewis, are you around? I'm going to slow roll the vote while we wait for Delegate Lewis to come back to her chair. The bill has been moved and seconded. Does anybody else have anything to say? I think we know how we're all voting, but anything else to add before I see no one else's hands up. I think he was talking to someone else. Okay, so what we're going to do is we're going to have people say aye, and then we're going to count hands for no
Madam
votes.
Chairman.
Yes, sir.
So since there's potential maybe 1 or 2 amendments to the bill, can we wait and hold the bill until we have the amendments in?
You mean in terms of for the voting session, Lisa? What is the voting session is at 5. What is the likelihood of getting amendments turned around in time for a voting session if we put this at the end of the voting session?
I mean, if you want to contact me as soon as we get out of subcommittee, then we can get something drafted.
Okay, I mean, one of the amendments, I'm not sure if Delegate Morgan wants to put one that put like something asterisk or something, but I think, going back, looking that if the hospitals are not going to hire someone that's not supposed to work, then this bill it's unnecessary and makes sense to either wait on the bill or, propose an amendment or wait to see the other bills that we passed, because at some point we're going to come back next year and we're going to have the issue of having many people that have been licensed and went to school because we spent so much money creating this workforce and now they don't have work because they're competing with people that are not here legally. So I think, this bill being premature, again, obviously I'm not supporting the bill because I think it's not just philosophical reasons, for many other reasons, but I'm also worried about our own workforce that we spend millions of dollars, like you just said earlier, on trying to promote, and we're not going to have work for them, and then we're going to have in the same crises that we have now. We have people being overemployed and competing, and I'm sure many people can share stories that many Americans, they've lost their jobs because somebody else was picked over them because they had a foreigner visa. So. But yeah, I'd like to potentially maybe hold the bill so we can offer the amendment if I can.
I think what we were discussing is we don't actually need to hold it. I think Lisa's offered to make sure we can get the amendments drafted in time for the voting session, since we are running up against the wire with sine die.
If anyone can just email me as soon as we get done with subcommittee, and then we will have something drafted and distributed to the full committee.
Thank you.
Later today.
Thank you very much.
Delegate Krebs.
And I will get Delegate Krebs the section of the federal code that you would like to see.
Thank you. And I just want to put on the record here for posterity. We had no House bill version of this bill. We just had the Senate bill presented to us an hour and 15 minutes ago. We've had many issues of legal questions about the bill. It's very important. It's important for public safety of our constituents. I cannot imagine how anyone can take a vote on this bill at this point with so many unanswered questions in 1 hour. So, and then we're going to vote it out of the committee at 4 o'clock. This is not the way that our committee does business. We do it very deliberatively. I think we've asked substantial questions about some safety issues, the issue about boards and who's responsible for doing what. When we pass this bill, we're giving the go-ahead to these hospitals, these employers, that they can do something. And really, they still can't. There's laws that prevent them from hiring people here illegally.
And
so-
the hospitals have been very clear with me on that, and I'm sorry they're not a subcommittee.
And I'm
today.
appreciative of the fact that you've had a lot of discussion with these hospitals, and I appreciate the work you've done. We haven't. This committee, all of us sitting here, got this bill 1 hour ago, and we haven't had that opportunity to have any discussion, and we're going to vote a bill through in less than 10 hours with all of these questions that have not been answered. And I don't think that's the way we put out our best product. And I think there's a way to get to I understand the problems that we're trying to solve. And if this was such a big problem, it shouldn't have waited till 3 days before the end of session in an hour, in a very short period of time. But these are substantial questions that we've had regarding legality and federal law. You already told us that they can't be a part of the interstate compact, which is, we've joined that for all of our boards and commissions. And I think that's pretty substantial. So, how are and on one hand, you tell us we can't be part of the compact. And then on the other hand, you said, oh, they're already doing all of this. So I'd like to know, is this current practice and we're just codifying current bad practice? And are we violating the compact because we are making this standard practice and it's illegal? So there's been so many different answers to questions that conflict with each other during this process that it's concerning to me. And I think we should really figure it out because, as I said, the compact.
Delegate Krebs, I have to say, and I know that I told the committee we would be done at 2:30, but it concerns me to hear you say that. I certainly don't think that I have had conflicting answers. So I think maybe, maybe I need to explain myself and the research that I did better on this, because I don't want you walking away from this subcommittee feeling like answers have been conflicting. So let me be very specific. The nursing board has the oldest compact. Not all of our boards and commissions have compacts. Many of them do. More and more have been doing so. They have the oldest compact, which in some ways makes it getting a little out of date. The way they have been enforcing their compact, it is a requirement to have a social security number. However, you can get a nursing license that is not a compact license. And all the Board of Nursing is saying is, under this law, this is what these folks would be eligible for, and they would not be eligible for a compact license. It's not in conflict with anything. So I just want to be really clear on that. The other boards, all of the small boards, the Board of Physicians that I've spoken with have said, again, this is not an issue that comes up all the time. It comes up infrequently, but when it comes up, it's someone who is eligible to be in the workforce. They don't want to hold up the processing. They can use an ITIN number, and that is happening. So it is both existing practice, and it will help us to have that clarified in the statute. It has not been the existing practice for the Board of Nursing, although they are welcoming it and like the bill with the amendments that clarify the language around the ITIN number.
So do we know currently, you're saying that we have certain people in the compact and certain people not in the just let's use the nursing board. So I'm assuming. So right now, currently, does our nursing board accept people that do not have social security numbers?
Right now, currently, we have nurses working in Maryland who have licenses from Texas and Georgia and Florida that have not applied any social security numbers. They are coming through those states from the Philippines and from South Korea. Adventist Hospital is getting a whole bunch of them, I think, next week. Like, this is happening on the ground all the time. And then the process with the Board of Nursing in the state of Maryland is lagging behind that.
So are they part of the are those people coming from those other places? Are they part of are they coming through the compact?
No, those are non-compact states. That's why they don't take social security numbers.
They're non-compact states. So do we know how many are in Maryland today that are Maryland licensed that do not have social security numbers that are coming with just an ITIN, and there's a separate log that they keep them in the Board of Nursing that this is the ones that have an ITIN, and this is the ones that have a social security number. Do we have any idea what, you just said there's tons of them here. Is there a log or something that tells us how many of those there are?
I said that there were tons of nurses that were coming from out of the country through other states that don't track social security numbers at all, which is
But
different.
they're coming to
from what you
Maryland.
said.
Are you saying they're coming to Maryland?
They're working in Maryland hospitals.
So how did
currently.
how did they get here to our Maryland licensure system?
It sounds like you need to have a personal phone call with someone from the hospital association. And I think we've got some time for you to do that. It's 2:49. So I'm going to recommend you get on the phone with them and they can walk you through exactly what's happening with nurses in the hospitals right now. So they can answer all of your questions since they couldn't come to
No,
the
Chair, just respectfully, as I've said earlier, it is the responsibility of the bill sponsor to make their case and solve we shouldn't have to be the investigators in the next hour. We haven't even had lunch yet, okay? So, I mean, I appreciate what you're saying. Again, we have 3 days left of session. We've rushed this bill through in a few hours here. And, you know, for me to have to go pick up the phone and do my investigation, and I appreciate the fact that you had time to do that in previous days. I didn't even know this bill existed until today. And I just
And
don't
so
think.
let me be clear, I knew about this bill because you think that there's no House crossfile, but there is a House crossfile. It just was assigned because it was broader. It used to include all of the professional licenses. So it was assigned originally to the Economic Matters Committee. I was over in that committee on a jointly assigned bill. So I was able to hear the original bill hearing, which does give me a huge advantage. Absolutely concede that, but I just wanted to make sure it was clear to the committee that it did have a crossfile.
It's not in this committee.
The reason it's in our committee now is because it was limited by the Senate to just the health occupations article.
Yeah, and we're the ones that have to make the decision on it in this committee, and that's a shame we
But
didn't
to
have.
be fair, Delegate Krebs, you are going to be a no vote on this bill. It's
You
not
know,
going to change.
I will tell, no, that is not fair to say. If you told me that they had to be lawfully present here, the amendment that we're trying to get drawn up, I think that would be a lot different for me of a decision than having someone here who has no limitation on time, whether they ever will be lawful. That to me, because at least it vets them from where they came from at some point. I mentioned that already. So that amendment saying they have to be lawfully present would encourage me to vote for the bill. So don't just make.
No, and I appreciate that. I agree. I understand that distinction. And maybe I will just toss it to Michelle Furman for a minute. One of the things that I learned at the bill hearing that this committee did not have the benefit of was sort of the discussion about what is happening with the current DREAM Act students, the Dreamers in Maryland, and particularly because that has been sort of stalled at the federal level, those folks who would be eligible for Dreamer status, but are sort of waiting and in limbo, and sort of how we solve for their professional aspirations. So I don't know if Michelle, you want to mention that a little bit, which is why, again, that sort of lawful status language gives me a little concern and discomfort. Go ahead, Michelle.
Absolutely. So there are currently about 13,000 other immigrants in Maryland who are eligible for DACA, but because a previous president ended the status in 2017, a number of applications have been backlogged and no new applications have been accepted since July 2021. As a result, these immigrants cannot obtain social security numbers, which are needed to obtain licensure in Maryland in health occupational fields. So this legislation would help the backlog of all of those students that have been here, that have went to school here, that have been trained here, and they just can't take that next step to get licensure.
Okay, Delegate Bagnall. Thank you, Michelle. Delegate Bagnall.
Thank you, Michelle, and thank you, Madam Chair. And I just want to, again, see if I'm encapsulating this and understanding it. So this bill is to address a backlog, a bureaucratic backlog that is from another agency. So if we don't pass this bill, it means that we have a backlog in our workforce that is also created by a backlog in just addressing this need for the Social Security number. So we are drawing out significantly the timeline of licensure for qualified health providers.
Mm-hmm.
Right, unnecessarily drawing out the timeline, and this would let us put that back into a more
Expedite that
compact
process.
cycle.
Okay, thank you very much.
Delegate Saab.
Thank you, Madam Chair. So I did hear something so there's a backlog on getting social security numbers.
There is.
So what is the backlog? How long is the backlog?
It can take up to a year from the research I did recently. But again, it's not just a backlog of Social Security numbers that Delegate Bagnall was talking about. It's a backlog of all of our immigration processing. It's taking months and months. So do the Ukrainian temporary status folks I was talking about before, right? 75,000 new Ukrainians. Heaven knows I want to do everything I can to help them. If they have healthcare licensure, I want to do what I can to help them. They have a temporary status, but it's going to take months for them to get their work permit authorization in many cases because of the federal backlogs.
So
With
do
that
they
in
have
mind-
equivalencies? So they have licenses, you said. So they have licensing from their own country. which
They may be
standard.
qualified for licenses, right? So if they are here and they're looking for a Maryland license, there's no reason to delay the Maryland licensure while we're awaiting months from the federal backlog for their work authorization.
So how long would it take? How long does it take to get the license? Because if you come from another country, now I don't know, does the United States have reciprocity with Ukraine? Because I know there are doctors like from Russian doctors and people that went even from Lebanon, doctors that when they came here, they have to spend years trying to go into school here. So speaking of the Ukrainians specifically, do we have reciprocity between our United States and their country? And if not, how long does it take? Do they still have to start? Like, where do they start? Because this could be
You have
2 years
to-
down the line.
Delegate Sub. Oh, go ahead, Lisa. Go
I
ahead.
was just going to say they still have to meet all of the current education and training requirements that are currently on law.
Right,
So
which could be 2-3 years from today, because it all depends on.
You have to keep in
requirement.
mind that this is not just nurses and not just doctors. We're talking about every health occupation. So, 38% of home health aides are immigrants, right? More than 25% of our physicians are immigrants. But if we're just talking about the CNAs, right? The folks who are in the greatest shortage of any healthcare occupation and the folks who are doing God's work, in my opinion, right? It doesn't take that long to get your CNA credential. Right? Like we want to make sure that this workforce is empowered with every tool that we have. And whether it's immigrants who are refugees or whether it's dreamers who are still in the pipeline waiting to get their paperwork processed, like we want to make sure that the second they're eligible to work, they're able to work because the shortage is profound and heartbreaking. And so, that's why the philosophical choice of letting our licensing board determine whether someone's qualified and letting the other authorities determine whether they're eligible to work.
Thank you.
Okay, the bill's been moved and seconded. I think we're gonna, with the understanding that folks will talk to Lisa about getting amendments drafted for the voting session, we'll call the vote. All in favor, let's see, who do we have? We still have people here. Okay, let's do this. Raise your hand if you're a yes vote. So we'll count you first. Raise your virtual hand if you're a yes vote. Put your little button on so that we can make sure to get it right. So Delegate Kelly's raising her hand as well. Okay, so we have Cullis, hold on, I just don't want to get it wrong because it's Cullison is with this K. Okay, Castro, Bagnall, Lewis, Landis. Okay. And now raise your hand if you are put your hand down if you're a yes vote and put your hand up if you are a no vote. Oh, my hand is going down now. Sorry, people. There we go.
In
Okay,
your
so we have,
heart, you want to vote no, Ariana.
we have
Yes
no
vote.
from Delegate Krebs, Delegate Riley, Delegate Morgan, and Delegate Saab.
Al, did you vote?
I intend to be a yes vote.
Al wasn't counted.
Thank you. You're very good friend, Delegate Lewis. Okay, so we have 1, 2, 3, 4 no votes, 1, 2, 3, 4, 5, 6, 7 yes votes. So thank you to the committee. Thank you in advance to Lisa, who is going to be working on amendments for the full voting session. And again, apologies for this committee always has a deliberative process, which I really appreciate. And I think everybody wishes we had weeks and weeks to work on this bill and get it just right. It is the nature of the legislative session that we can't always do that. And I will just remind the committee that with the exception of Delegate Krebs, but she can always call us and give us her feedback. We can always make tweaks next year if we need to, if we find they're necessary. That ends the subcommittee and we have a voting session at 5. Anybody have anything else to add? No, Lisa, did we do everything? You're looking at me perplexed. No,
No, I was reading. No, we're good.
reading the federal law. Okay, thank,
The public health is meeting like momentarily, so.
excellent.